The clock has, by a miracle of modern engineering, been fixed by the court clerk. Thank you very much. Yeah.
Good afternoon. I was on the question of new evidence and wanted to take the court to the judgment from Mr Justice Waksman in tab 7 at page 48, paragraphs 67 and 68.
Yes.
And that's where the judge finds, as part of his analysis, what the new materials were and the fact and result of the testing and energisation and so on. He goes through the features of that evidence and says at the end the fact that Sudlows contended that the new matters take matter no further is irrelevant. They did in the eyes of Mr Molloy. That is a view which cannot be challenged. And then at 68, we were not repeating an argument without more. He was relying on testing and reports being event and evidence that simply didn't previously exist. That was in turn a function of the fact that adjudication 5 couldn't deal with the entirety of the relevant contractual period since it had not yet expired. So that's the, and we commend that analysis to this court.
Yeah.
It leads into my further point in relation to new evidence, which is one has to ask, well, why has the new evidence come about at the time it did? And the reason is because Sudlows chose to start the adjudication at the time it did in relation to the relevant period of 18th of January 2021, before practical completion. So they did so necessarily knowing and taking the risk of the fact that subsequent evidence may develop in the narrative. This is an ongoing live project, facts still unfolding. Mr Justice Waksman picks that up in paragraph 68, that this project was still ongoing. One asks, therefore, if they had, and they're perfectly entitled to do that, but that's their decision. One asks, what if they had chosen to wait until shortly after practical completion, when all the evidence was in? On the basis of Mr Molloy's decision, the outcome would be different. And we submit there's no reason to shut that evidence out. It would be absurd to ask, should be absurd, that Mr Molloy was required to close his eyes to what actually happened. If the position is that he was jurisdictionally precluded from taking account of that new evidence, he'd be simply shutting his eyes to what actually happened. And in my submission, the law of adjudication should be flexible enough to cater for that state of affairs, especially as matters unfold during the course of the contract. Otherwise, Mr Molloy was being asked to create an artifice which would be an extraordinary outcome. It's important in this way. If the purpose of adjudication is to resolve disputes and stem the flow of finally determinative litigation, that purpose will be undermined by obliging adjudicators to ignore new evidence which subsequently emerges and which has such a demonstrative impact. The relevant consideration is not that it was new evidence that we could have failed to obtain. It was evidence that hadn't happened. And as Mr Justice Waksman said, that conclusion can't be challenged in this court. Mr Justice Waksman, again, paragraph 68, accepted there was no artificiality on our part. This is not us casting round for evidence that could have been obtained before. I want to move to a different point which relates to what my Lord described as the contractual point. This relates to the power to review matters of practical completion.
Yeah.
Let me say...
Was that a misdescription by me?
Well, it is a contractual issue, but my learned friend has given me a clue as to what he's going to say, which is, well, this is a new ground not relied on below.
Okay.
I did, in fact, argue the point, albeit briefly, below, but it doesn't feature in the judgment. but let me be clear about this. What I primarily rely on this argument to show is that the contract itself recognises at the end of the project a review of extensions of time. And that review can perfectly legitimately come to a different conclusion on extensions of time from those which obtained during the currency of the contract. In my learned friend's language, those would be completely inconsistent with each other. I wouldn't use that language, but nonetheless, the concept of a review is perfectly well understood. So I rely on this argument to show that there's nothing to worry about here. It's perfectly understandable.
But that mechanism wasn't invoked here.
Well, or was it? Maybe I misunderstood. So what happened was that they applied for their payment application and in their further extension of time after practical completion.
Right.
Yes.
So at a time when, had the contract, had the matters run their course, there would have been such a review.
But there wasn't.
Well, my point, well, one can...
Was there or wasn't there, first of all, before you make the point?
There was no... Mr Molloy's decision in adjudication number 6 was not specifically premised on the basis of it being a review. I accept that.
Well, he had no power to make a review under the contract. The power under the contract was given to somebody else.
Well, it was given to the contract administrator.
Quite.
And then if there's a dispute about that decision, it goes to the adjudicator.
But Molloy that wasn't the dispute that was referred
Well,
to Molloy.
The problem was adjudication number 6 was a kitchen sink adjudication that reflected the fact, as my learned friend accepted in his submissions, that practical completion had occurred.
Yeah. So it was a kitchen sink post-practical completion claim.
Correct.
There was no separate or specific invocation of clause 225.2.
Correct. Yeah. But as a matter of chronology, the fact is, if one had been looking at that time, that chronology would have fitted very neatly with the circumstances of a review.
Yeah, but so what?
So what? Well, perhaps I need to go through the review in a little more detail. The point I make, the point I will demonstrate, is that necessarily involves a reconsideration of evidence, however extensive the previous considerations may have been.
Well, you may well be right about that, and that may have been an avenue that was open to your clients, but they didn't go down it, so it doesn't actually affect the decision that we have to make.
Well, my lady, the point here is that both of these adjudications were not brought by us. That's a further feature on which I rely. These are serial adjudications not brought by us. We had nothing to do with them. We were responsive to them. They were both brought by Sudlows. That is the feature which is also recognised by the judge, and we were responsive to this. We were entitled to defend our case.
Of course you were. I understand that completely, but the principle of whether something has been previously decided or not in a dispute can't depend on which party actions the adjudication.
Well, it may well depend in the circumstances of whether the dispute is the same or substantially the same. As we look in the cases, one of the deterrent features which the courts have emphasised is that parties bringing claims should not be able to have a second go.
Well, that's part of the policy behind it. But it's not, as I say, it doesn't actually have a bearing on the factual question, which is whether or not it was the same or substantially the same dispute.
Well, it is part of the fact and degree test, which is taken into account. We'll see that when we come to the cases, that who the fact that a party who loses first time round has another go but improves its evidence, that is something which the policy in the fact and degree assessment has taken against, and that's not our case. But I can.
So that's something that you say is relevant to fact and degree. I understand that. Yeah.
It may be that the court's already had a look at the contractual provision, but it's tab 13, page 123. So, sorry, page 122, apologies. Clause 224 requires the contractor to give notice of the events causing delay, and then 224.2 on page 122, apologies. It's tab 13 in the core bundle. Notice under 224.1 and then particulars under 224.2. And then at 225.1, the employer's agent is required to react to the giving of notice and particulars by reaching a decision on extensions of time as notified. And so that's a reactive duty to assess extensions of time during the currency of the contract. Then at 225.5, not later than, I'm reading from the second line, not later than the expiry of 12 weeks after the date of practical completion, the employer must give the following details, and he either he fixes a completion date later, and then importantly, whether on reviewing a previous decision or otherwise, and whether or not specifically notified. 2, he can reach an earlier date, but only in limited circumstances. Or 3, he can confirm the completion date previously fixed. So that is a significant duty. It's not responsive to notice, and it has the benefit of looking back over the entire contract period in order to work out what the position is. You can't take away extensions that have been given, but you can decide not to grant any more. And that's, in our submission, a proper approach. It recognises that events causing delay should only be seen ultimately in the course of understanding the full facts as they emerge during the currency of the contract. My law will be familiar with delay analysis, looking at matters retrospectively at the end of the project and understanding the full context. And my learned friend, as I say, has recognised that his adjudication number 6 was intended to be a post-completion wrap-up. I suppose one could ask the question this way. So, suppose he didn't like the answer that he got from Mr Molloy in relation to extensions of time. Could it seriously be argued that the certifier should be entitled to ignore the conduct of that prior adjudication? I would say it was obvious to everybody who participated in it that it was a post-practical completion review. But I don't need to go that far. My point is that review necessarily contemplates reaching a different decision from one that had been granted hitherto. And that was what Mrs Justice O'Farrell decided in Essential Living and Elements, which is at tab 11. So just taking us to that.
Tab 11.
Tab 11,
yeah.
The authorities part. So this was a contract, slightly different form, but the same structure. Paragraph 16 on page 178 of the bundle, you will see familiar provisions akin to the ones that we're looking at here.
So it's just a different JCT form.
Exactly.
Yeah.
Paragraph 22, on the 5th of July 2019, the works were certified as practically complete. But on the, paragraph 24, the notice of adjudication predated that. So notice of adjudication 9th of April 2019, the practical completion had been on the 31st of May. There was a long and lengthy adjudication in which, as it was, my clients did not do spectacularly well in getting the extension of time. I wasn't involved in this issue. But they didn't get as much of extension of time as they had wanted. And the adjudicator, Franco Mastandrea, produced a decision that granted a limited extension of time. The matter then went to the construction manager to make his decision on the 12-week review. And what happened was that Essential Living, the employer, issued proceedings for a declaration that he, the construction manager, was bound by the adjudicator's decision. So paragraph 39 on page 182 Essential Living issued proceedings seeking declaratory relief that the elements, I'm now reading from 2, elements was not entitled to any extension of time beyond those already assessed and awarded by the adjudication decision, unless were altered by the court. So that was, they in effect said, look, we've all had a jolly good thrash through this in front of the adjudicator. It would be absurd if on the 12-week review, the construction manager could simply ignore that and reach a different conclusion. Paragraph 41, and Mrs. Justice O'Farrell identifies the issue before the court under Roman 1 as the impact of the adjudication decision claims for extension of time. Paragraph 47, she records my submission, I'm identifying the prior paragraph, about halfway through paragraph 47, the sentence beginning, further the dispute referred. Further, the dispute referred did not include the 12-week fixing of the completion date, as practical completion had not yet occurred. The right to a post-practical completion decision in respect of extension of time arises under 227.5 and is conceptually different from any earlier decision that may have been reached during the currency of the works. She went then through various authorities with which this court will now be familiar, paragraph 54, including Benfield, Quietfield, Carillion, and so on. Then, if I could pick up, please, at 61 on page 189. Essential Living's case is that Elements is seeking to reopen the delay issues determined by the adjudicator in the adjudication decision. Substantial portions of the Hunter report and the fresh submissions to the construction manager rely on the same events and causes of delay as previously argued in the adjudication. In any event, the underlying dispute cause of action remain the same or substantially the same. And Mrs. Justice O'Farrell said there is force in the argument to the extent that it's simply concerned with an attempt to overturn or modify the adjudication decision. However, it ignores the limited scope of the dispute referred, namely the correct valuation of the account as it stood in March 2019. At 63, regardless be had to the contractual procedure set out in 227.5, mandating the construction manager not less than 12 weeks after the date of practical completion to determine the completion period for the work that is fair and reasonable by reviewing a previous decision or otherwise, and whether or not the relevant event has been specifically notified. 64, she points out that the time for their exercise had not expired when the adjudication decision was issued, and no such exercise had in fact occurred. Nothing in the contract or the scheme suggests that the resolution of a dispute as to the completion period under 227.1, that's the interim claims, would displace the obligation to assess the period under 227.5. The latter provision mandates a separate exercise and expressly permits the construction manager to review any previous decision. Therefore, the adjudication decision could not, didn't purport to determine any dispute arising out of the fixing of the completion period. Makes the same point at 65, and then at paragraph 68 concludes, it follows that the adjudication decision is not binding on the parties for the purposes of the construction manager's final determination of the completion period under 227.5, from which would flow any liability for liquidated damages. And at 84.3 on page 192 summarises that conclusion. And so the point is, it was open, notwithstanding the adjudicator in that case gave extensive consideration to the material before him. It was a very lengthy adjudication. Nonetheless, when it came to what it was that was to happen after practical completion, a review exercise with the benefit of all the knowledge that had been acquired up to practical completion was required to be undertaken. And that exercise did not preclude, therefore, the running of arguments made in the light of knowledge which now existed at the practical completion stage. So there's nothing surprising, therefore, in a position in which a party, either the certifier or in default the adjudicator, I say in default, in the event of a dispute, the adjudicator, at the 12-week stage, reaching a different conclusion on extension of time from that which had been granted hitherto. There's nothing unusual about that at all, even if, as I say, to use my learned friend's language, they might be seemingly inconsistent. So this is all perfectly in accordance with the contractual matrix, which is what happens during the currency of the contract, all it is subject to review at the post-practical completion stage. Now, whether one looks at Molloy as being an exercise of that review or not, the fact of the matter is it was...
But how sorry to interrupt, Mr. Nissen, but how can the sixth adjudication have anything to do with the exercise of this power by a different person? I just don't understand it.
But because the parties were in dispute, essentially, I don't know that there was any
But
evidence.
the construction manager hadn't exercised its power, as I understand it.
The employer, under this contract, we don't have a construction manager.
Right,
It's the employer's agent. But the point is, the parties essentially, or Sudlows essentially, took the matter straight to adjudication. I don't know that there's any evidence about quite how that circle was squared. But after practical completion, essentially, they simply went to the adjudicator for a decision. Now, my point is, I don't need to say that, as a matter of fact, Mr. Molloy was exercising that function ascribed.
You can't say it.
Well, I don't know whether I don't know whether the parties turned their minds to that. It would be odd. I simply put it this way.
But I mean, if you're going to make the submission, surely there needs to be some foundation in the facts of this case for it.
The point I'm making is that the existence of that regime demonstrates that it is perfectly possible, in respect of a subsequent period, to review new events as they now appear.
But it doesn't prove that a second adjudicator looking at the same relevant event can review an earlier decision of an adjudicator dealing with that same relevant event. It just doesn't follow.
The second adjudicator was dealing with a different period. was
know he was dealing with
reading a different
Same
paper.
relevant event, though, isn't it?
Well, we'll have to come to it. Well, our submission is it is not the same
Oh,
relevant
I
event.
see. Okay.
It's a different relevant event. I'll come to that in due course.
All right.
It's an ongoing breach claim. So although it relies on the same clause, it's not in fact relying on the same facts. But that I'll come to that. My point.
You're relying on this, as it were, by analogy, simply to say, well, look, the fact that there's a review can't come as a surprise to the parties, because a review was built into the contract. Whether or not that was actually what was happening here is a different point. That's the point. And so, at the very least, you rely on that as an answer to Mr. Stewart's doomsday position.
Absolutely. I do go slightly further in this sense. As a matter of chronology, if the 12-week review had taken place post-practical completion, it would have encompassed the events which actually occurred.
Yeah, the trouble about the alternative world is that on one view of the chronology, practical completion didn't happen until after Mr. Curtis had decided adjudication 5. So there's cause and effect between adjudication 5 and practical completion. So it's quite difficult to say, well, if they'd waited, because none of us might be here because practical completion might still not have been certified. Well, so it was adjudication 5 that led to practical completion.
Adjudication, well, no, what happened was that there was a standoff which would have continued. The only way we could resolve that standoff without waiting 18 months was to get access back to that part of the site which we wouldn't otherwise have had access
yes,
to.
But you'd asked for that in the summer of 2020.
Been refused.
Yeah, and that was the point you were making this morning.
Exactly.
So
it's a standoff.
So the sort of the what if scenarios here are not straightforward.
Well, as a matter of fact, whether it would have happened in the 12-week period or at the end of the project, either way, in order to finish this project, the cables had to be tested and energised, and the downstream works undertaken. My point is that any subsequent consideration of any later period would have taken into account that feature. As a matter of fact, it would have taken included in the 12-week period. So there is nothing startling, and my lord has the point, there's nothing startling about a review of this type. I do say, therefore, that that's a relevant feature. I also make the submission, we'll see it when we come to the cases, that the way in which courts have dealt with the issue of same and substantially the same dispute is different when it comes to extensions of time because of the fact-sensitive nature of those events and their capability to change over time. Those are my submissions in relation to the new evidence. Can I now move to the question of the scope of the dispute and decision and start with the notice of adjudication in adjudication number 5, which is in the supplemental bundle at tab 2. And I'm inviting the court to read these documents, knowing that the way... apologies. Supplemental bundle, tab 6, page 13. Apologies. That's the notice of adjudication number 5.
Yeah.
I'm inviting the court to read these documents, mindful of my learned friend's contention that what was being asked for was some contractual point of principle being determined. Paragraph 5.1 on page 16. What was being sought by this notice of adjudication was a dispute has arisen in respect of Sudlows' entitlement to extension of time in respect of delays up to 18th of January 2021.
Yeah.
5.2, this adjudication is concerned only with delays caused to the completion date of Section 2 and only in respect of delays occurring up to 18th of January 2021. At 6.1, Sudlows seeks decisions or declarations from the adjudicator that it's entitled to an extension of 509 days or such other period it shall decide in respect of delays between 3rd of March 2019 and 18th of January 2021. And that was, as we can see from page 17, the date of this notice. So one of the things that the Court of Appeal was asked to look at in Quietfield and Vascroft was the breadth or reach back of the first adjudication. What was it asking to do? And as my Lord has identified, what is the shape of the dispute between the parties by reference to fast track at that time can only have been such right to extension of time as Sudlows had acquired by 18th of January 2021. And that's all in accordance with, that notice is given in accordance with the scheme as reflecting the dispute as it stood.
You say that qualifies paragraph 5.7, do you?
Sorry, I'm saying what?
Are you saying that that qualifies paragraph 5.7? In other words, you've got to read 5.7 against the deadline dates that have been put in?
Yes. Sudlows' intention to refer the dispute...
Delays to the second... It's their intention to refer to adjudication the dispute relating to Sudlows' entitlement to further extensions, plural, of time in respect of delays, plural, to the Section 2 works occurring after the 3rd of March 2019.
Yes.
Because the words to adjudication are out of sync in the sentence. You're just looking at that on the face of it and basically saying any delays after the to the Section 2 works after the 3rd of March are within the scope of this adjudication. You say that's qualified by 5.2, which says it's only in respect to delays occurring up to the 18th of January.
Not just by 5.2, but by the relief sought in 6.1. And it would not be possible, with respect, for an adjudicator at that stage to express any conclusion on a right to extension of time in the future, or events occurring in the future. It's just not possible. And consequently, the decision was responsive to the relief claimed. If we can go, please, to Core Bundle 17. Core Bundle, apologies. 14. This is Mr. Curtis's decision.
Yeah.
And we go to page 283. What Mr. Curtis does under the heading decision at the top of the page at 16.3 is give his responsive decision in respect of the dispute that's been referred to him.
Yeah.
And what he does in 16.3a is quote the articulation of the relief claimed in the notice and then give his answer in respect to it.
Yeah.
So
and there's the date that I was looking for before, 8th of December 2020.
Exactly.
Yeah.
Yeah. And that's short of the indeed. So he quotes in the first paragraph directly from the notice his decision with a capital D in response to that request is an entitlement of 482 days and changes the completion date or declares the completion date in subparagraph B. So it's entirely responsive to that and my submission is that neither the notice of adjudication nor the referral nor the decision which is responsive to it purported to express any conclusion, factual or contractual, on the position thereafter. And Mr. Justice Waksman had that well in mind in the last 3 lines of paragraph 69 of the judgment, where he says, on the other hand, Mr. Curtis did not decide that the relevant events found were so for all times and for all purposes going forwards, even if on their face they were or could be relevant events causing ongoing delay. There was no question of contractual risk or contractual responsibility. The learned friend, with great skill, no doubt, has sought to identify and characterise the Curtis decision as being one relating to contractual responsibility. And he does that to avoid the inconvenience of the emergence of the new evidence. So he says it was a contractual conclusion which necessarily ties the hands of Mr. Molloy, irrespective of subsequent factual events. But that simply isn't right. The conclusion that Mr. Curtis reached was that the bundle of facts which had occurred up to the 18th of January had this consequence. That tells you nothing, in my submission, about the bundle of facts necessary to consider delaying events thereafter. It was Sudlow's decision, as I say, to stop the clock at the 18th of January. If they had let it run on until practical completion, further events and stories would have been taken into account. As Mr. Justice Waksman identified, paragraph 69, the dispute in adjudication, I'm reading from the first 2 lines of 69, you don't need to take it up, but it says, the dispute as characterised above is, as against that dispute, as characterised above, there is a dispute which was referred to adjudication 5 and the decision thereon. That dispute concerned only a claimed EOT. And so our submission is, although it contained detailed analysis, and I accept that, the fact is Mr. Curtis was only ever deciding a package of facts up to a given day. And this is relevant because this, the event which he must have determined to have existed was itself although he doesn't articulate it respectfully in a clear way, was an impediment, prevention or default. That's the clause, that's the factual clause on which this claim was hung. And that's an ongoing question, which necessarily must be determined depending on the circumstances which then thereafter occur. I say he determined it as an impediment, prevention or default. That's how Mr. Molloy certainly understood it, paragraph 139 of his decision. So what we need to look at is, therefore, how we need to read the decision was framed against Sudlow's characterisation and framework of the dispute as being up to the given period. At their choice, that was their choice. My learned friend has taken the court to the decision, and I only want briefly to go to a couple of pages from it. And this is still tab 14 of the core bundle. the paragraph 14126. I'm sorry. Paragraph, page 261, paragraph 13289. Your Ladyship will see this interim conclusion that Sudlows were correct and entitled to refuse to connect and energise the cable. So, and that's based on his articulation on the prior page of what he understood to be our position. At paragraph 13283, where he records us as saying that Sudlows were being unreasonable in their, i.e. Sudlows' refusal to terminate the cable and energise the works. So, as the court's already been told, that's not the characterisation of the dispute as correctly identified, so far as our position is concerned.
Yeah, but you're stuck with that.
We're stuck with that for Curtis.
You're stuck with that.
For Mr. Curtis.
Yeah, absolutely.
Yeah.
But so therefore that's of the 2 points made by Mr. Molloy, subject to the other points, of course. But that first point is, well, if Mr. Curtis got that wrong, you're stuck with it.
Yeah, and he's right about that, at least for the period that Mr. Curtis was dealing with. As you
yeah, that's why I say it's subject to the point about, well, it's a different period and so on, which is a separate argument. Which is why I cavil at the amount of time, energy and cost that went to the Mr. Curtis was wrong. Well, so what?
Yeah.
I mean, it may be just a question of presentation, but to give the parties do need to help adjudicators, even adjudicators as experienced as Mr. Curtis and Mr. Molloy. Anyway, there it is. On that point, speaking for myself, I understand the submission that Mr. Curtis misunderstood, you say, that point, but for the purposes of the period up to the 18th of January, that's what adjudication is all about.
Absolutely, but it doesn't. That doesn't stop Mr. Molloy from addressing what is in fact the correct question in the subsequent period. Then at paragraph 14.1.3. Sorry, 14.130 on page 278. One sees the adjudicator totalling up the periods of delay across windows 14 to 29, and one can see in respect to window 29 over the page 234 days, summing up into 482 days as the total extension granted. And so, and that total of 482 days is then what forms part of his decision at page 283. And I accept, and have accepted, that the decision on page 283 at least can reach back to that quantification of the amount of delay in respect to window 29. But I say that's the reach back of it. When we come to Hyder, your lordships and lordships will see that Mr. Justice Edward Stewart, when determining what the scope of the decision is, was influenced by what is on the content, what is under the banner of decision. And that's why I pray the limited elements of what is contained on page 283. In other words, in drawing the line between reasons and decision, I say this adjudicator clearly intended the decision to be what he separately identifies up on page 283.
Yeah.
But with the limited exception that it can also include the computation of window 29. That is, in my submission, the particular position. I accept, of course, that the identification of the relevant event was an issue in adjudication number 5, but I say it is not part of the decision. And if you reach back, so to speak, at too granular a level, you import into this process the concept of issue estoppel, which is not appropriate for adjudication. In supplemental bundle 22, supplemental bundle tab 22, at page 236, 326, apologies.
Yeah.
This is a surrejoinder that was before Mr Molloy. And at paragraph 6.120, Sudlows themselves accept that the further period for which it sought an extension was not in strict terms the same dispute. They say, however, it's a continuation of the story. But there's an acknowledgement there that it is not in terms the same dispute. And our position is they're correct, because adjudication number 6 related to a different claim, a different cause of action in respect of extension of time, namely a later period. It necessarily depended on a review of facts which occurred going forward in the subsequent period, being from the 19th of January onwards, and a proper analysis of those facts showed that the position is as Mr Molloy in fact found them to be, but felt jurisdictionally precluded from considering them. This is different, we say, therefore, from, for example, a relevant event which is a singular thing that you can identify. For example, if they've sought a declaration from an adjudicator that there had been a flood, which was a specified peril, then one can see in that type of case the reach of a conclusion that a specified peril had occurred would be if an adjudicator had concluded that, could have an effect in a subsequent claim because of the declaration that had been sought. But where the relief sought relates to an ongoing breach of contract, which every day constitutes a breach, then it is necessary to establish a new package of facts in relation to that.
Even if it stems from the same relevant event? Even where you've got a situation where you've got one relevant event which has been identified, and any delay that is said to flow to the construction project stems from that relevant event, you say that the identification of that relevant event and the fact findings about it become immaterial second time round because you've got to go through it all over again.
The relevant event is a contractually defined set of things, and the relevant event with which we are concerned is one which it's not a single thing, as I say, like a flood or whatever. It's essentially a breach of contract, and the nature of that breach is that every day for which that breach occurs, there's an entitlement to an extension.
Yeah, so the breach starts on day 1 and it continues until day 365.
But there can't be unless there's a declaration sought that enables consideration of that question. You can't, in my submission, make any findings as to the future.
I don't understand. Sorry, it's probably me being incredibly obtuse to listen. why the nature of the relief sought has any bearing on whether or not there is a breach of contract or not. If somebody finds that there's been a breach of contract, there may well be different consequences, or there may be a supervening event that stops it from being a breach of contract. But if your claim is quintessentially dependent upon a breach of contract which continues and doesn't stop, then why is not the finding that there is that type of breach of contract binding on both the parties?
Because that was not the way in which the dispute was framed. They chose to take it up to a particular point. They couldn't have known at the date they chose to take it up to that point what the future held.
Well, they couldn't have known what would happen after the date that they referred the dispute to adjudication, admittedly. But if the delay continued without something new occurring, you've still got the same breach.
But one can only analyse those questions, which may themselves be disputed as to whether there's been a change of circumstance, in the subsequent review of the period. One can't forecast at the 18th of January what the position is going to be. Any number of things might happen in the future, and it's impossible prior to that to determine the reach of that first decision until the story unfolds. It is perfectly correct in hindsight that Malone and Friend says, well, we weren't alleging anything new by way of event. We were, of course, relying on new evidence, but all of those things only become apparent afterwards when you know the story. That's why it's necessary for them to come up with some new facts. One can test it in this way. So suppose in a subsequent adjudication, there's a dispute over whether the factual circumstances were different or not. They say they were the same, we say they weren't. How does that get resolved? It can only be resolved by starting afresh with a reconsideration of the position in a different window. As I say again, they chose this window, we didn't. Therefore, that's the risk that they took. One asks this question: if Sudlow's case is that we were bound by the decision of Mr. Curtis in the period leading up to the 18th of January, in a way which impacted in the subsequent period, why did they refer that dispute to Mr. Molloy? Necessarily, on their case, it was not a dispute over which he had any jurisdiction to decide. They did not rely in the adjudication before Mr. Molloy on Mr. Curtis at all. They only did so in response to our defence. So they took it upon themselves to prove the claim in the subsequent period.
Well, I wondered about that because they started the adjudication. If Mr. Molloy had resigned, saying, well, that effectively has been decided, that would have been a bit of an odd result. Mr. Stewart says, well, no, because there were other claims.
Yeah.
But this was the principle, or this was the thing that lay within it. And they certainly took the point that effectively, because we looked at one of the documents this morning, they took the point that effectively this was just a continuation. But I understand the point that they started the second adjudication effectively on the basis that Mr. Molloy did have jurisdiction.
Exactly. It's a contradiction where we say they were right to vest him with jurisdiction to decide the position over the new period, because that's precisely what it was.
But the fifth adjudication could not have decided whether there was any entitlement to an extension of time in relation to the period which hadn't occurred at the date
Absolutely.
dispute was referred. So if they wanted a further extension of time, surely they had to ask for another adjudication, didn't they?
No, because they could have simply relied on the binding effect of the adjudication decision of Mr. Curtis. Could have gone for summary judgment in court for a declaration that they had a right to the further time by reason of the reach of the Curtis decision.
But you've been submitting that the Curtis decision couldn't reach into the future.
Absolutely. I'm saying, sorry, my hypothesis is what I think my lady was asking, well, what were they supposed to do? On my case, they were supposed to do exactly what they did do, which was to start another adjudication and vest Mr. Molloy with the ability to consider all matters afresh in that new period.
Well, it doesn't. That's a non sequitur.
That's the question.
I mean, they go for a further extension of time in relation to the new period, but it doesn't follow from that they're asking Mr. Molloy to revisit every single issue that was decided in the fifth adjudication, does it?
Well, that they don't rely in their proceedings on the Curtis decision as part of its claim.
I think what it boils down to, Mr. Nissen, putting it very, very simply, is that you say the scope of what was decided in adjudication number 5 was a narrow scope, and it was purely whether or not the other side were entitled to an extension of time up to the deadline when they started the adjudication. That's pure and simple. That's what you say it is. That was the whole of the scope of that, and nothing that was decided in relation to that period has any bearing on whether or not they were entitled to a further extension of time for a later period.
I certainly do say.
And that, as I understand it, is really your case in a nutshell.
It's my case on the periods, that being one of the reasons. The other reason is that in respect of the dispute, we're entitled to rely on new evidence, which we couldn't have obtained before.
Well, that would only be right if you're right about the periods.
With respect, no. As we'll see, and I'll come to shortly, a number of these cases, Quietfield was one of them, is where the new evidence was permitted in respect of the same period.
That was only because the issues were different.
It wasn't, with respect, it wasn't only because of that. But we'll come to that. I'm conscious of the time.
Yeah.
The point is that the reach, they say, of Mr. Curtis's decision is not just in relation to loss and expense. They also say it entitles them. Sorry, it's not just limited to extension of time. It also applies to loss and expense, a financial entitlement based on a different provision in circumstances where there was no claim made before Mr. Curtis at all for loss and expense. He wasn't concerned with that, and therefore their position, which they satisfied Mr. Molloy, was they had no option but to award loss and expense, not, of course, merely for the period awarded by Mr. Curtis, but also in respect of the subsequent period. He had no entitlement to review that question at all, and for the reasons that Mr. Justice Waksman mentions in paragraph 34, we submit that's not correct.
But on the money, well, that was the point I was asking about this morning. I thought that on the money, the position was that just find it.
I referred your...
The difference was effectively the second period.
The difference was the second period.
The loss and expense and the liquidated damages. Loss and expense one way, liquidated damages the other thing. It's that. So the position in relation to the extension of time up to the 8th of December 2020.
Mr. Molloy gave them liquidated damages.
And that's...
I'm sorry.
Gave them liquidated damages. So that's the first period.
Correct.
Well, sorry. I was asking that this morning, and
So he gave them loss and expense for the Curtis period, and he gave them loss and expense for the subsequent period.
right,
In the alternative decision, which was enforced by the learned judge,
yeah,
Mr Molloy had crafted the alternative decision so that Sudlows retained the loss and expense in respect of the Curtis period,
right.
but had to refund the loss and expense for the Molloy period.
Right.
Yeah.
And
So the loss and
damages taken
expense.
accordingly.
So the loss and expense for the Curtis period isn't in dispute.
Correct.
So
Just to be clear, it was in dispute before Molloy.
Yes.
yeah, I understand that.
Yeah.
But that's why I've said in my note, which is not disputed on appeal.
That's right. And indeed before Mr Justice Waksman.
Well, because, sorry, just to be clear, what we did in these proceedings was to enforce the alternative decision.
Yes, I understand that.
So when
And the
we
alternative
agreed-
decision gave them loss and expense up to the 8th of December.
Well, now, if it's not for us on the adjudication enforcement to say Mr Molloy got that. If that's a wrinkle that's not consistent, there's nothing.
No. I'm just. It's not a question. It's not. There's no clever point behind the question. It's just understanding
So
the.
in the
figures.
alternative decision, Mr Molloy let them keep the loss and expense for the Curtis period, and we then sought to enforce the alternative decision.
Yeah, but I'm just testing the point about, because I understand the point that a claim for loss and expense is a different claim.
Yeah.
I understand that, but that point doesn't arise for determination.
It does because.
But that's not in dispute, because it's whichever of his two outcomes, he gave them the loss and expense.
No, he gave them the loss and expense for the period that he felt he had no jurisdiction to deal with.
Yeah. So whichever way you cut it, they get the loss and expense for that.
No, I'm sorry.
They get the loss and expense for the Curtis period.
Yeah.
I've just noted
yes.
that down.
Yes, absolutely.
And they
Sorry.
get that. They get the loss and expense for the Curtis period, whichever of you are right.
Correct.
So it's not in dispute on this appeal.
That
I
is-
appreciate these parties find it difficult to engage with the concept of something not being in dispute.
No.
But for the purposes of this appeal, that's not in dispute.
Agreed. Apologies.
Can I go home now?
The loss and expense in respect to the Molloy period is obviously different.
Of course, yeah, I get that. All the second period stuff, yeah, I get. Yeah.
I shouldn't want this court also to get the impression that because Mr Molloy had a greater package of issues to deal with than Mr Curtis, that he was dealing with the matters in any way in less detail than Mr.
No, I think it's 320-something paragraphs.
Absolutely. He also had, just by way of chronology, he had 2 hearing days, which Mr Curtis didn't have any hearings. So there was a lot of work, and the adjudication ran over a prolonged period.
Whatever happened to 28 days, or even 42?
And I think the answer is the reason that adjudication of these types of disputes is so attractive is because it allows the parties to have some say that is a little longer than Parliament had intended.
It should be a package.
Well, those are interesting topics for another day.
Wait until you're in adjudication.
Right.
I'll be saying 28 days and that's it.
I think the short point is that parties recognise that the more peremptory and brief is the period of adjudication, the more rough and ready and the less satisfied the parties feel that they've had their go.
I get that.
And that's and extensions are all of time of the process are always consensual. They have to be.
Yes, they do have to be. But after a while, it can become a bit of a loaded gun if you've agreed an extension. But anyway,
Anyway,
yeah,
that's
there it is.
beyond this.
Yeah, okay.
I'm going to move on to the law,
Yes.
if I may, and I'll deal with the cases largely in the order in which they appear in the bundle. So, Quiet Field, I anticipate the court has already had a look at this.
Yeah, well, just, I mean, obviously, we're familiar with the cases and we've looked at some of them at any rate with Mr. Stewart, so it's only really if there are other parts
Yes.
in any of these.
So, I start on Quiet Field by noting, it's not be lost on your lordship, it was a powerful court.
It was a powerful court upholding a powerful first instance judge. I mean, it is, as two of these were referred to recently in a extracurricular thing that I chaired, the rock stars of the TCC.
Absolutely.
And I forbore to say, but I'm tempted to do this on another occasion, that we had Lennon and McCartney being introduced by Ringo.
How do I follow that? I'm going to actually read the last sentence on page 23 of the bundle, in which Lord Justice Dyson says, in my view, this is not a borderline case. So this was a case which he felt was very clear in the way that it sat. The other aspect that I wanted to draw your lordship's attention to was that when Lord Justice May comes to analyse the law at paragraphs 18, 19 and 20, he introduces them by reference to section 1083, paragraph 23(2) of the scheme, and paragraph 9(4) of the scheme, and asks in the middle of paragraph 20, the question then was how section 1083 of the Act and paras 9 and 23 of the scheme interrelated with the usual provisions of extension of time. So any suggestion by my learned friend that there's been a wrong turn somewhere along the way in the consideration of the interplay between those provisions, we would respectfully disagree with. The focus of 9.2 is largely a product, I submit, of the way in which these cases have panned out. It's just the facts, but to adopt a comment made earlier, they're a package of clauses designed to deal with a particular scenario.
Yeah.
And that's how we invite the court to review them. The facts are at paragraph 8 of Lord Justice May. Very, very briefly, Bancroft made two specific applications to the architect for extensions of time in two letters. That's paragraph 8. Paragraph 9, the second application was in a letter dated 22nd of April. And at the bottom of 17, you can see they asked for an extension of time so that the date for completion was the 23rd of September 2005. So that was the original application. Paragraph 10, the architect didn't grant them. There was then a new notice of adjudication. And at paragraph 13, Lord Justice May recites line 4, in relation to the claims for extension of time, he decided that the two letters were contractually valid notices, just pausing there, those being notices of the type that we looked at earlier. But Vascroft had not provided, he decided the two letters were contractually valid, but Vascroft had not provided either evidence or reasoned analysis to demonstrate that the events on which they relied caused delay. He stated that Vascroft had failed to discharge the burden of proof that they were entitled to an extension of time. So an abject failure on the part of Vascroft to demonstrate any entitlement to an extension of time for the period up to practical completion. What then happened was there was a second adjudication in which the employer sought liquidated damages for the non-achievement and they so that was the second adjudication. But we can pick the story up at 15. Vascroft resisted Quietfield's claim in the third adjudication, containing that they were entitled to an extension of time for the whole period on the grounds set out in Appendix C to their response. The judge described Appendix C in paragraph 22 of his judgment. It's a bulky document, spans 400 pages, sets out numerous causes of delay, traces the critical path, analyses the delay caused by each of the relevant events, bar charts, etc., etc. And there was then an issue, as we see in paragraph 16, as to whether the adjudicator could pay any regard to Appendix C or whether he was precluded. He dealt with that as a preliminary issue. He decided he was not able to have regard to Appendix C because he was bound by the decision given in the first adjudication. He considered that Vascroft's defence to the claim for liquidated damages was seeking to rely for a second time on the same matters as they had unsuccessfully relied on in the first adjudication, but on different evidential submission. The point here is what's clear from these facts is that Appendix C covered not only the same grounds as were included in the letters, but as we will later come to see, some new ones too. But the adjudicator, for his part, was focused on the fact that there was the same material in there. And that what the new evidence comprising Appendix C was about was essentially evidence. Then the law is then analysed, and at paragraph 21, Lord Justice May notes what Mr. Justice Jackson, as he then was, summarises the law, and he says those principles are correct for the purpose of the present case. Now, in fact, it's worth noting that in 21.1, in the third line, the words different grounds, that those words are themselves qualified by Lord Justice Dyson, paragraph 42 of the judgment, where he explains or qualifies what is meant by different grounds, because what he says is those grounds can be the same relevant events, but with some further particulars or possibly evidence too.
Yeah.
So then at paragraph 23, Lord Justice May again recites from the judge, and who said Appendix C is a far cry from the two application letters. And then this: it is perhaps regrettable that Appendix C was not advanced in the first adjudication. Appendix C identifies a number of causes of delay which do not feature in the two application. And then this, and I rely on the word further, Appendix C appears to be a structured and logical document setting out to demonstrate the critical path and so on. Whether at the end of the day the submissions of Appendix C will prevail, I don't know. That will be a matter for an adjudicator. I'm quite satisfied that Vascroft's entitlement to an extension as set out in Appendix C is substantially different from the claims for extension time which were advanced, considered and rejected in the first adjudication. So features that we can take from Mr. Justice Jackson, as he then was, is that it was regrettable that Appendix C was not advanced, and secondly, that it was or included forensic evidence which necessarily could have been prepared for the first adjudication. Paragraph 25, Lord Justice May.
I've just noticed. I notice in that citation from the judge at first instance, there he's talking about Vascroft's alleged entitlement to an extension of time. 3-4 lines up from the bottom. I am, however, quite satisfied that Vascroft's alleged entitlement to an extension of time, as set out in Appendix C, is substantially different. So it doesn't. That would suggest that the sword shield point isn't a relevant consideration, wasn't thought of as a relevant consideration, because the judge is there looking at it as a sword, even though it was a shield because it was a defence to the claim for liquidated damages. Okay.
He then at paragraph 25 goes on to consider the nature of Appendix C, and he says he's quite satisfied that Mr. Holt wasn't correct not to persuade us that Appendix C comprised the same claims dressed in different clothes, nor is this a claim where the only differences were tendentious additions designed to make what was substantially the same claim look different. The point there being, if it is literally window dressing, same a claim document with a few extra paragraphs in, that wasn't going to, that wouldn't change the character of the dispute. And we contrast that, of course, with our evidence, which Mr. Molloy described as compelling, as having a significant impact.
I mean, the point that's being made in paragraph 25 is that Appendix C has got a fairly sophisticated and new critical path analysis.
Yes.
It goes on to say it could well be that grounds for extension of time which were not established individually in the first adjudication could nevertheless legitimately feature in Appendix C.
Yes.
Because the point about the first adjudication was the adjudicator did not decide that there was no entitlement to an extension of time. What he decided was they hadn't discharged the burden of proof.
He certainly said that, but he refused it. He certainly said that, but he said they've not provided either evidence or reasoned analysis to demonstrate that the events on which they relied caused delay.
Yeah.
That's
Yeah.
what paragraph
It wasn't a finding that there were no grounds for an extension of time. It was a finding that they hadn't proved that they were entitled to one.
Yeah, that is exactly the position in which, having had their go at it, the suggestion was that they couldn't come back and do a better job second time round, even though they could in fact have done that which they ultimately did the first time round. The other critical feature of this case, upon which we rely, is that the period of extension of time sought in the two letters ran for the entire period. That's to say, up to the date of practical completion. And yet, in this decision, they were entitled subsequently to rely on Appendix C in respect of the same period.
Are you saying that Mr. Justice Jackson's principles, when he's referring to successive applications, means successive overlapping applications in respect of the same period? Or is it in principle at least possible to read that as meaning successive applications for extensions of time relating to different periods?
It could mean either, and that's something that Lord Justice Dyson looks at.
Yes.
He considers it, in my submission, it could be either.
Because the reason I ask you this is because I wonder how that has a bearing on your point about different periods. If the principle in relation to successive applications can apply to applications for extensions of time based on the same grounds but for successive periods in sequential periods, then how is that reconcilable with your submission that because there is a claim in respect of a different period, that's a completely different claim?
No. My point really is that I submit that Quiet Fill is an a fortiori case for me because it allowed consideration of new evidence in respect of the same period as had been dealt with by an adjudicator, whereas I'm relying on new evidence for a different period. And I say, therefore, it's an a fortiori case.
Before we leave page 72, can I also ask you, please, a question about paragraph 26? See if you can help me on that. Yes, my lady asked you about paragraph 25.
Yes.
Lord Justice May says that the first ground of appeal was in principle capable of succeeding if it was in truth correct that the scope of what was decided in the first adjudication was much broader than the judge found, so as to embrace not only the specific grounds for extension of time in the two letters, but also all claims for extension of time. Right. Now, I'm interested in the words "so as to embrace not only the specific grounds for extension of time in the two letters." Does that not suggest that if that what Lord Justice May is saying is that if you are reiterating the same grounds for extension of time in a successive adjudication, in principle, the ground of appeal would have been capable of succeeding?
I think what he's saying is what you have to look at is the scope of the notice of adjudication in the earlier adjudication.
But it doesn't refer to the notice of adjudication. It says what was decided.
Well, I'm sorry, what was decided.
Yeah.
To see if the nature of that decision focused or referable to the notice pursuant to which he'd been appointed.
Focus appears to be on the grounds on which the claim was made, and the decision relates to those grounds. So it's not simply you're entitled to an extension of time, but you are entitled to an extension of time because one or other party is in breach of contract.
Yes, as I said, what was necessary was to look at the breadth of the initial document in order to see what was decided. And my point when I took your ladyship, my lord, to the judgment, to the decision of Mr. Curtis, there was nothing in that which enables my learned friend to say it had any contractual effect, let alone factual effect, going forward into the future. So, in principle, what Mr. Holt then did in paragraph 28 was to refer the court to the notice and said it could be read as a broad request, and the judge should not have looked at the. He shouldn't only have looked at the notice; he should have looked at the referral and so forth. And down towards the bottom of 28, the scope of the first adjudication should be construed as embracing all claims that might have been for extension that might have been made. That was the submission that was being made, which he rejected. So I'm saying simply that neither the notice nor Mr. Curtis's decision responsive to it purported to decide anything going forward into the future. That's what Mr. Justice Waksman made clear. And then just continuing at 28, the last two lines of page 20, there was nothing in Appendix C which could not have been put forward in the first adjudication. Certainly, but the question is whether matters in Appendix C were put forward in the first adjudication. So there's an acknowledgement there that Appendix C contained nothing that couldn't have been put forward first time round.
These are all the submissions, aren't they? This is all Matthew Holt's submissions.
That may be so, but
I think that's right.
I'm about to say I have read it differently, but at all events, it doesn't appear to be disputed in principle that the analysis could have been obtained before.
Oh, I see what you mean. Yeah, no, I get that. There's no question of something later. No, I see that.
So that is the analysis of Lord Justice May, and one then turns to so one can see in my submission that the features that impacted upon Lord Justice May were that Appendix C comprised new material which didn't feature in the application letters, certainly, but it was also not the same matters dressed in different clothes or tendentious additions, and therefore was relevant to the considerations which the third adjudicator should have taken into account. But so that's Lord Justice May. Can I then go, please, to Lord Justice Dyson, who not only looks at it from the point of view of the adjudicator, but also of the certifier.
Sorry to interrupt you, Mr Nissen.
Yes.
Would you accept what Lord Justice Dyson says is obiter? See paragraph 39 of his judgment.
No, respectfully, because Lady Justice Smith agrees with both judgments.
No, well, I know she does. But what he says in paragraph 39 is, I agree, this appeal should be dismissed, blah, blah, blah. That is sufficient to dispose of this appeal.
Yes.
I would add a few words of my own to expand on the first of the two principles. So isn't
I
it
think what
obiter?
my lady is saying is that when we do that, we like to think it's obiter.
Well, I'm certainly not going to cavil with that then.
Well, it's just a simple question. The answer's either yes or no, isn't it?
Well, it seems as though the answer is yes.
Right.
But can I put it this way?
Yeah.
That the comments, if they are obiter, I don't think that distinction is one that's been...
I mean, certainly the analysis of the contractual provisions is different. I mean, Lord Justice May doesn't do it that way. So he doesn't look at the contract provisions. So you referred to 42, which is qualifying Mr Justice Jackson's first principle. That's not something which Lord Justice May does. So that's a helpful, different
yes, it's an
element.
He's really looking at the way in which matters have to be looked at.
I mean, really, Lord Justice Dyson is focusing on the contract, really all the way through, and then he contrasting that with the position with the architect at 44, and then we really only get to the adjudication type point at 45 onwards.
Yes, and which I rely on because in my submission it's helpful. It identifies, in fact, the test of being a question of fact and degree, and I'm not sure, in fact, Lord Justice May uses that expression, no. But the fact and degree has...
Para 47. Lord Justice May, you said, yes.
No, this is Lord Justice Dyson.
Lord Justice Dyson uses it in 47.
My point was, if Lord Justice Dyson is to be treated as dicta, nonetheless, the question of fact and degree is established law, if I may respectfully put it that. What Lord Justice Dyson is doing is saying, look, if this is same old stuff, then the people operating this on the ground and then thereafter the decision makers will be able to tell the difference between the two. And at paragraph 48, where the only difference between disputes is that the later application makes good shortcomings of the earlier application, an adjudicator will usually have little difficulty in deciding the two disputes are substantially the same.
Would that not also apply if the only difference is the later defence makes to a claim for an extension of time makes good shortcomings in the earlier defence?
There is, as I said earlier, there is a difference between claimant and referring party and responding party. But I absolutely make clear I'm not making, Global Switch was not making deficiencies good in the later period in any culpable sense. It's relying on things it could not possibly have availed itself of. That's a critical feature in this story. Although, as we come to see later on, the reliance on matters, even where the party is culpable for not having got its act together, even that's not enough. It wasn't enough inquiry. They could have done all of that, and they didn't. That didn't matter. Benfield...
But that was because of the nature of the dispute that was referred to the first adjudicator. So, I mean,
Well,
the ratio of quiet field is paragraph 39 of Lord Justice Dyce's judgment. He says the dispute which was the subject of the first adjudication was substantially different from the dispute which was the subject of the third adjudication.
Yes, but this was a dispute which the contractor himself advanced.
Yeah.
So the circumstances in which Appendix C came to be introduced were that were sufficiently different as a question of degree. It included the same events as had been relied on before and some more. So there was overlap, which was not inconsiderable, but that nonetheless did not preclude it being a different dispute.
Substantially different.
Absolutely. So that in my submission, is what we take from that. The Benfield is a case of my lords. The position in relation to that, we entirely agree with the principles that my lord identified in paragraph
34.
34.
Those are the ones that Lord Justice Simon
Yes, endorsed.
approves in Brown.
Correct.
Yeah.
The facts of Benfield, however, were markedly different from our facts. The central, it doesn't relate to an extension of time claim, and indeed, at paragraph 26 of the judgment, my lord notes that point. You say, the lordship refers to Mr Justice Jackson in Quietfield and says it's unnecessary to set out those in the judgment, not only because those were expressly concerned with adjudications concerned with extension of time, which is not this case, but because of HG construction. And HG construction itself recognises that this is not an extension of time issue. So if one goes, please, to page 34, paragraph, in the indented paragraph just above paragraph 36, Mr Justice Ramsey, in the last 4 lines of that indented paragraph, says this is not a case similar to applications for extension of time where there is a changing factual position and later extensions of time are based on a different set of facts. This was a case in which, putting it very shortly, there was an adjudication about the date of practical completion and the effect of whether a handover form constituted contractual or factual evidence that completion had occurred. The adjudicator reached his decision about that, and then there was a subsequent adjudication in answer to the claim for liquidated damages, in which the contractor now sought to argue that there was a partial possession argument, which it could avail itself of. And my lord, in my submission, quite rightly said, well, this is not an opportunity for a second go. Partial possession was all part of the practical completion date argument, which should have been happening on the first occasion. So it doesn't relate to extension of time, and it was not a new evidence case in an emerging narrative. It's a classic case of a new argument, always available to the contractor, for which the evidence was always available, and which could have been run in the first adjudication, but which the contractor failed to do. Unlike, therefore, Benfield, we have our new facts upon which we rely. And the Lord considers, in my submission, quite rightly, in the fact and degree test, of paragraph 43 and 44, page 36, the dispute was the same or substantially the same. There was no different material facts presented in the third adjudication. Paragraph 45, Mr Stansfield said it cannot be said there's a changing factual situation. think it's impossible to reach any other conclusion. And so that is the position there. And then in paragraph 51 and 53, my lord was concerned with, in the last couple of lines of 51, did it amount to the serial adjudication of matters that could and should have been raised before? And 53, the last couple of lines, confirms my view that the court should be vigilant to prevent serial adjudications, matters which could and should have been raised first time round. And your lordship went on at 55 to talk about placing an intolerable burden on the person on the receiving end of notices of serial adjudication. And again, I say it is important, therefore, to bear in mind, and this is one of those cases, that shows we're not the person who's bringing these claims in a serial adjudication way. We were the respondent to both of these adjudications. So if anything, the intolerable burden works the other way. It was Sudlows who commenced the serial adjudication. They could have waited until practical completion, but it was they who chose to expose us to the cost of 2 adjudications. Carillion is the next case. There is the circumstances of that case are again far removed from ours. One can see, for example, at just above, so on page 71 of the bundle, this was a case in which a contractor, Mr Smith, had put in an extension of time claim. He lost on it. He then came back for a second go and relied for these purposes on documents which had emerged during the course of the first adjudication, and which he said, therefore, he was able to recast in a different light. And in the middle of the paragraph 59, one can see, page 71, Mr Justice Aikenhead saying this: it is apposite to point out that Mr Smith and his company had a substantial time in possession of the documentation upon which he now relies in the third adjudication claim before the conclusion of the second adjudication. He was served on the 2nd of July. It was not until the 28th that he delivered his decision. It's absolutely clear that, in fact, Mr Smith, in his reply, considered extensively, to the tune of 240 pages worth, Carillion's response and attached documentation. It cannot be said that he did not have and largely take the opportunity to challenge and react to respond to the further documentation. So this is a case where, unsurprisingly, Mr Smith failed to say, in his attempt to have a rerun, and also a critical feature of this case identified at the bottom of paragraph 58 was that the period up to which delay and disruption occurred and was being maintained was the same, whereas of course that's not the position in our case.
The judge does seem to appear to think in paragraph 54 and 55 that in working out what is in dispute in the first adjudication, one isn't wedded to the notice of adjudication.
Well, he certainly, the way Mr Justice Stuart Smith, as he then was, analyses this decision in Hitachi, is that there was excessive focus on the referral.
Maybe so, but I'm just looking at what the judge says in the context of adjudication. The starting point would be the notice of adjudication and referral document.
Yes.
Although one can, of course, look at the period leading up to this stage to assist in the definition of the dispute. However, one must also be able to consider the issues raised within the adjudication proceedings in this regard. And he gives an example of where something is in a valuation dispute, it's articulated later And then he goes on to say one needs to look at the substance and essence of each dispute which is being referred.
Yes.
It seems to me to be rather against you on the question of everything being completely constrained by the referral letter.
I'm not saying everything is constrained, but I think what he is doing in the principles, which he begins at paragraph 56, is to place reliance on reference.
Yes.
Which, for the reasons analysed by Mr Justice Stuart Smith,
Yeah.
is not appropriate. In this case, though, to be clear, there is coincidence or coinciding between the dispute referred and the decision. The decision is precisely responsive to the dispute and confined by the window with which it was concerned. In the principles that, or factors, should I say, paragraph 56(2), what the judge does is to say that new evidence will not usually alter the essential dispute. The reason is that evidence alone does not generally alter the essential dispute. My point here is that if that is a factor, it's a factor which allows a degree of flexibility. And because it's not saying it necessarily cannot alter, it becomes, of course, a question of fact and degree. And in our case, if new evidence emerges in respect of the later period, that can be taken into account. A factor which we rely on in paragraph 8 is that the cause of action is in respect of a subsequent period, which is a different period from that which was the subject of the original claim. So we say there are features of this, insofar as it's helpful to look at these factors at all, they are factors which support it.
Is it right that the cause of action is in respect of a different period? Surely the cause of action is the same breach of contract or alleged breach of contract. The damages relate to a later period.
No, with respect, it's a claim for an extension of time over a particular period.
So the cause of action is the contractual right to make the claim for an extension of time. Yeah.
Hyder, tab 5.
Yeah.
Mr Justice Waksman deals with that case, paragraphs 54 to 61 of the judgment. We respectfully endorse his analysis. He distinguishes it in the first instance as it being not a case about this topic at all, but one about breach of natural justice. The facts are not straightforward, no time to go into them. But paragraph 36, what's important here for the analysis is that the learned judge identifies the decision, paragraph 36 on page 86, the decision as being the declaration that the particular sum is due. So that is his starting point. But he then qualifies that by paragraph 37, where he says, in the example that he gives, the computation of the amount so declared, if there's an element or an ingredient in the computation, then that part is also part of the decision. So in the case of Y weeks, Y number weeks being the extension of time, the amount of that extension of time would also be binding. One gets that in the last 3 lines. In my judgment, in that situation, the adjudicator's conclusion on the amount of extension of time would also be binding on the parties. And Mr Justice Waksman accepted that that was the reach of that paragraph. And so one has to read paragraph 38 in light of that. That's to say, if the amount of the extension was an essential component of the award, then that amount is part of the decision. And paragraph 39, in the present case, the scope of the decision is quite clear because it is set out under the heading, the decision. And I mentioned that point earlier. This is therefore an important case in the context of the issue with which the Court was then concerned. We've submitted in our skeleton, it's not a helpful test to import into this field with which we're currently concerned. But it does support our submission that the dispositive relief, as explained, is the extent of the reasoning, is the extent of the decision, and one can't go back into the reasons. After all, if you can go back into the reasons, where does it stop? At what level of granular detail do
Well, it's a
you
matter
go?
of judgment, surely.
Yes.
I'm sorry?
That's a matter of judgment.
Absolutely.
Fact and degree.
Absolutely.
Because what the judge is saying in paragraph 38 is the decision consists of the actual award and any other finding in relation to the rights of the party. It forms an essential component.
Yes. And in his example, the essential component was the number of weeks that form part of the decision.
Yeah.
That's the feature of what he was saying.
I think that language is echoed by Mr Molloy when he considers the
Yes.
scope of his jurisdiction to revisit.
He did, and the point is, this is not a case about the issue. It's not a case governed by the Court of Appeal issues on the topic with which this court is concerned. But at all events, even if it is capable of being carried over, we say the reach of it is that the essential ingredient is that they were entitled to an extension of time for events up to the 18th of January in respect to the matters on which we rely. Pardon and pace, I don't think I need to take you to Crown and Complete Solutions. It is a short point, but again, there was a notice in December 2013, a final certificate. The adjudicator decided that certificate was no good. They served another one they got their act together, served another one for exactly the same amount in April, and the Court of Appeal said different period, different consideration, different dispute. And again, nothing at all surprising in that, but it emphasises the importance of looking at the period over which the new adjudication is concerned. And that's why we rely on that decision. Because we say Mr Curtis was for an earlier period, just as the first decision was concerned with an earlier set of events. Hitachi, tab 8, is a case in which we also rely on. The analysis I respectfully agree with it is extremely helpful. The simple point, paragraph 38 of Mr Justice Stuart Smith's judgment, is that what the first adjudicator was doing was analysing the question for the purposes of interim payment application number 6 for event 1176. He was not at 38.3. He did not decide the valuation of event 1176 for any other purpose than in the context of the claim pursuant to payment application number 6. And so the point is, when a subsequent claim is advanced, the adjudicator is entitled to consider the matter afresh. It wasn't relevant, or at least determinative, that the failure to have adduced the evidence first time round was culpable. So at paragraph 41, Mr Justice Stuart Smith cites Quietfield and Carillion. He says neither of them paragraph 41 on page 135, neither laid down a hard-edged rule that disputes should be regarded as being the same or substantially the same if there is an overlap of evidence. to the contrary, in Quietfield, as in this case, the remedy originally sought, there an extension of time, was the same, and there was an overlap of evidence when compared with the substance of the dispute that was referred in the later adjudication. And then at paragraph 43, I recognise the theoretical possibility of what Hitachi calls serial adjudication being used as an instrument of oppression. That's not the case here. And of course, at least on my client's side, it's not the case in this case. What has happened here is that CISC misjudged the evidence that was necessary to substantiate a valuation for event 1176. This was a large construction contract. I see nothing oppressive about this approach. If parties were to act oppressively in the adjudication process, you'd find the court unwilling to lend its assistance in a claim for enforcement. But I repeat, that's not the position here. So again, it's taking a broader view. Is this an oppressive case? Was it, whose fault was it that the evidence was or wasn't available? And so on. All in the context of the acknowledgement that overlapping evidence is perfectly permissible. It all depends on the circumstances of the case. We submit, therefore, that the context of this was a different application, different payment, and that's why we say it's a helpful case to us in circumstances where the adjudication before Mr Molloy was in respect of a different application for one event over a different period. Lewisham and Breyer, a case of Mr Justice Waksman, sets out helpful principles in paragraph 34, where, and we particularly rely on 34 bracket 6 on page 150, for, again, its reference to the fact that extensions of time, by example, are treated differently from hard-edged cases. Mr Justice Waxman, subparagraph 6, for example, an application for an extension of time based on a particular relevant event, the particulars of its expected effects, and all the evidence used to prove them, may lead to the conclusion that overall the dispute second time round is not the same as the first. I've taken that shortly, but that's the sum of that. And then global switch and Sudlows at tab 10. My learned friend sought to say this was a difficult decision. I submit it's a perfectly understandable decision. If the comments, if the passages upon which I rely are obiter, so what, respectfully. We aren't in this court concerned with the precedent aspect of it, but whether the analysis, careful analysis of the judge was correct and is helpful. The position in that case was that Mr Curtis had awarded an extension of time, and there was then an adjudication before Mr Davis to evaluate loss and expense. And I'm picking up from page 172 of the bundle, where the learned judge goes through the cases at 69, and then at paragraph 70, my learned friend's submissions are that were that Mr Davis, this is my learned friend's submissions, Mr Davis, the fourth adjudicator, found that Sudlows were not entitled to an extension of time in relation to strip-out works, with the consequence that no loss and expense was due. And that was a finding which was contrary to Mr Curtis. That was his submission. He was also submitting that Mr Davis found Sudlows contractually liable for structural enhancement works, and therefore not entitled to loss and expense. And that was also contrary to Mr Curtis in this earlier adjudication, having found that those matters gave rise to an extension of time. So that was my learned friend's position. At 71, Global Switches Council points out that there was a decision that Sudlows were entitled to an extension of 292 days, and that in the fourth adjudication, Mr Davis expressly accepted the extension was binding on him. At 72, the decision in the second adjudication was solely concerned with entitlement to extension of time. As part of that determination, Mr Curtis decided that the additional strip-out works and structural enhancements entitled Sudlows to extensions of time, but he did not consider or adjudicate the entitlement to loss and expense. So the line was being drawn not at the reasons why the events were given, but the fact of the extension. That was the reach of the decision. It is true, as Mrs Justice O'Farrell says, as part of that, Mr Curtis decided those features which applied. But the decision was you are entitled to an extension of time. Then at paragraph 73, the decision in the fourth adjudication was concerned with valuation and loss and expense. Mr Davis decided that the valuation of the strip-out works change was nil because those works fell within Sudlow's contractual allocation of risk. And later on, expressly accepted as binding the decision of Mr Curtis, that they were entitled to extensions of time. So, in other words, what my learned friend was seeking to do is to say, well, the very ground upon which we got the extension of time for Mr Curtis, meant that Mr Davis's rejection of consequent loss and expense by interpreting the contractual provisions differently was illegitimate because it was seeking to go behind Mr Davis's decision. And Mrs Justice O'Farrell said, no, absolutely not. The decision was an extension of time. There's no challenge to that decision. What we're now concerned with is loss and expense. And Mr Davis's decision did not trespass on that earlier decision. And in those circumstances, he was perfectly entitled to reject the claim either on contractual grounds or, in fact, he also found that they were unsubstantiated and therefore gave nil. So my learned friend says it's a difficult decision, but in my submission, it's just a decision which doesn't fit with his thesis. It is perfectly plain. If one understands the reach of the decision was limited to the extension of time for the period, it did not deal with loss and expense at all and didn't purport to. And in those circumstances, when it comes to loss and expense, the second adjudicator was entirely entitled to seize on the relevant matters as they appeared before him. Well, that deals with that. Essential elements I've dealt with.
Yeah.
My point, I think, in relation, I've got one small point left in relation to the scheme. I've made the point that Quietfield and all the other cases themselves consider all of these as a package deal in this territory, because they rather depend on the set of facts as to how the case manifests itself.
Yeah.
But my learned friend, I think, relied on the word matters in the first sentence of paragraph 20, as somehow suggesting that there was something more granular that is decided by the adjudicator than the dispute. I think that was the essence of his point. And my submission on that is no. The whole structure of the scheme envisages one dispute, and it is that singular dispute which the adjudicator, in respect to which the adjudicator reaches a decision. It is not, therefore, matters is not to be equated with each and every issue that arises in the case. That's not what is here referred to. There is one dispute and one decision in respect of that dispute. The plurality of matters, in my submission, takes its colour from the second and third sentences which follow that first sentence. For example, if one goes to the third sentence, in particular, this is over the page, in particular, he may open up, review and revise a decision of a certificate. He may decide a party is liable to make a payment, and he may award interest. So those are encompassed as matters in any dispute. So, and there are other matters that the adjudicator can decide if the parties agree that they can. So the plurality of matters here is, if you like, the parallel parasitic remedies which are encompassed within the dispute. It's not a mandating that each and every issue in the case has to be decided. There's a single dispute, and that is it. So
but it's the contrast or the potential conflict between a single dispute on the one hand and fast track what can be encompassed in a single dispute on the other that gives rise in some of these cases to a consideration of what the adjudicator actually decided, and questions of does it also include the essential components, reasons, that sort of thing, because the issues sometimes in these cases such as this focus on that, or end up requiring the court to focus on that, because the problem is otherwise you've got a single dispute on the one hand and a million different points on the other. Paragraph 553.1. So it is inevitable that courts faced with these disputes are going to be looking for some form of workable way of resolving that potential conflict.
yes, although there hasn't, I mean, obviously there have been some cases as we see, but I mean, generally the concept of what constitutes the decision is pretty clear, and adjudicators are careful to identify that in the decision.
Well, they are, and adjudicators are very used to doing that, I'm sure, and that brings us back to the fact that Mr Molloy thought that this was something that he couldn't decide.
Because
you've made submissions about that, but I mean, that is a factor. I think adjudicators, if I may say, do a very good job policing this.
Yeah. I'm going to just set out my conclusions.
Yeah, that was you dealt with paragraph 2, yes, so that was your final bit, yeah.
I'm going to just give a list, if I may, of 10 features, well, there may be 11 actually, which we say are relevant to the question of fact and degree assessment, which is necessary in this case. First, the project was ongoing at the time of adjudication 5.
Yeah.
Thus, it was Sudlows who decided to adjudicate its claim during the currency of the project rather than wait until the narrative had completed. That is permissible, of course, but runs the risk that the new narrative may change the outcome. 2, it was Sudlows who chose to define the window and scope of adjudication 5. They didn't seek a decision which reached forward to practical completion, nor could they. Nor did they seek a declaration or determination of any contractual allocation of risk, nor did they claim loss and expense. 3, a claim for impediment, prevention or default necessarily has to be re-established on evidence of what occurred within the new window of time. 4, it is not impermissible to take account of further material. Whether you can does depend on the circumstances. In our case, the new evidence necessarily was not available because it did not exist, and there was no failure on our part in not having adduced it before Mr. Curtis. 5, the new evidence was a set of factual events in time which only occurred later, not the collation of evidence which was previously available but not undertaken. The new evidence is not artificial window dressing. 6, it's not artificial window dressing or us seeking to make good on our own failure, although, as we've seen from Hitachi, not even that is necessarily a bar. 7, we were respondent to both adjudications. This is not a serial adjudication brought by a losing party, CF Carillion, or indeed Benfield, or us making good our own failure. We are respondent to both adjudications. 8, the evidence, the new evidence, compelled a different result, and it's not open to Sudlows to argue otherwise. 9, the inclusion in this contract of a post-practical completion review shows that interim decisions can subsequently be revisited in a post-practical completion review and reach a different / inconsistent decision. On the facts of this case, the timeline, as I've already submitted, would seek to demonstrate that. 10, and this was Mr. Justice Waksman's third point, the shape of the dispute was in adjudication 6 was different from that in adjudication 5. And 11, and lastly, there will be no floodgates given the features of this case, which are unusual in the respect which I've identified, which is new evidence emerging during the consideration of the subsequent period, the effect of which impacts on the prior period as well as the subsequent period. That's a slightly unusual case. And so there's no floodgates point, essentially. There's no floodgates point.
No, I understand.
I'm sorry, I've used up a lot of time.
Thank you very much, Mr. Nissen. Yes. Mr. Stewart, anything in reply?
Well, Lord, there are a few points in reply. I think I could actually fit them in under my learned friend's 11 points, unless you've got them freshly in mind, I can deal with them. Running through very briefly, his first point is that this was an ongoing project, and actually that fits into several other points that are made. That is true, but it was ongoing only because there was an impasse between the parties which had to be broken. And that dispute was as to the contractual responsibility for the standoff. Now, the learned friend doesn't shy, and his solicitors shy even less, from saying that Mr. Curtis got this all wrong, etc., etc. But the fact that Mr. Curtis considered this is absolutely abundantly plain, both from his decision. Can I just ask you to look at Core Bundle tab 14. And if you go to paragraph 13.199, what you see...
Hold on. Core Bundle 14, page...
Core Bundle tab 14, page 249. What Global Switch did was consistently try and say there's nothing wrong with our ducting, there's all these changes, you're taking responsibility for it. And you see that being concluded by this at 13.195, and you see at 13.198, Sudlows described the situation as an impasse or stalemate between Global themselves. Just above, Global refused to accept they had any responsibility for problems and repeatedly contended in correspondence the problems should be rectified by Sudlows at its own cost. And then you see 13.199, the stalemate is documented in the lengthy chain of correspondence between the parties between December 2019 and September 2020. Now I'm told There are over 1,400 pages before Mr. Justice Curtis. You have only been given a small little snapshot of that, but you can see that what Global Switch were always doing was saying, you do it, it's all at your risk, even though, as is now found and not disputed, it was entirely their fault that they'd got the ducting wrong. It was entirely their fault that the ducting had got bends, it was at different things, and so on and so forth. And you see at Global, the correspondence, a small part of which my learned friend took you to, which is the supplementary bundle. And if you go to tab 2, you see Global Switch writing on the 16th of July, just before the letter he did. They're saying that they intend to exercise its contractual right to employ a third party to undertake the installation work, and then they demand cooperation. The following page...
Well, we've looked at this. Is there...
No, we didn't. We didn't look at that one.
Oh, do we not?
No.
I've got that marked. Maybe I looked at that in...
Well,
But what?
can
I'm
I
just
just
conscious of the time.
I am very sorry, my lord.
Yeah.
But if one goes to page 10, after the parts which my learned friend took you to, as to what he said they were being terribly reasonable about, at the bottom, for the avoidance of doubt, we note the above tasks constitute work within Sudlows' scope, as work the Sudlows would always have to do under the contracts, not additional work. This letter doesn't amount to an instruction requiring or constituting a change.
Yeah.
And the response for that, which my learned friend didn't show you on the 31st of July, note your request. Sudlow confirms its willingness to cooperate, but for the reason that the issue with the HVV cable is not due to any default or breach of contract by Sudlows, and one sees the reservation of rights. Now, that chain was in place from beginning to end. And throughout, the position was being taken by Global Switch, we've done nothing wrong, you've got to put this all right. And that was the dispute between the parties. And the learned friends came, they saw, and they lost. Mr. Curtis looked at a video of the CCTV of the installation works, and he showed that they were all over the place. They put in a different cable. All of that was battered away. And that was decided, it was decided, it is true, only up to the 18th of January, but as my lord observed, the only reason it was the 18th of January was that was the date we issued the adjudication notice. The adjudication notice gets issued, the adjudication award gets issued in May. In June, the Global Switch omit the relevant works, which they could have done ages before, and practical completion is certified in June of 2020. Now, they have 12 weeks to exercise the rights in relation to clause 2.25. They don't do that. That right expires on the 31st of August. Insofar as my learned friend is making a point that there is a contractual right here, now I think well, I'm not sure whether he's making a point or not, but it's not open to him. It's not mentioned by the judge. My learned friend, I think, fairly conceded that it was, at best, extremely faintly argued before the judge, but there's no mention at all in the judgment. There's no respondent's notice, which would be required if it's going to be upheld in relation to that. It would be a hopeless ground anyway, because there wasn't any review, and the right to any review expired 12 weeks after practical completion, and so could come to an end by the 31st of August. And so in relation to any kind of review, it simply plays no part whatsoever in the discussions you have. If anything, what it shows is that the parties, having had the discussion and decided the points, any rational contract administrator or any rational employer would then say, well, obviously I accept. Having had this enormous great dispute, you're obviously entitled to a further extension of time. I give you that extension of time. I'm going to challenge it in the courts in due course. They didn't do that. We, of course, asked them to do that. And so when the matter goes and we seek the extension of time and the loss and expense, the dispute there, the learned friend said wrongly that we hadn't relied upon the adjudication decision. In the notice of adjudication for adjudication number 6, we actually do identify and rely expressly, sorry, the referral at page 206 of the supplemental bundle. We say, paragraph 11.166.5, accordingly, the natural consequence and direct effect of paragraph 13.289 of the decision in adjudication number 5 was to determine Global Switch was responsible for the ongoing delays which continued right up until practical completion. Sudlows is thus entitled to a further extension of time. The additional delay is an extension to window 29. So the dispute which we referred to Mr Molloy was essentially saying, you wrongly haven't given us the extension of time to which we're obviously entitled. And their response was to come back and say, no, we're going to re-argue this whole matter. The learned friend then says, well, you've got to have it as an ongoing issues. Well, the first point is obviously that the two sets of tests which are referred to are in August of 2021. They're after practical completion. They're not in the ongoing project at all. There are a whole series of points which I won't bore you with as to why these tests are eminently unsatisfactory. The relevance...
That's definitely not for us, is it?
It's definitely not for you, but the only reason I make that point is my learned friend was eventually showing that, saying, look, it's obvious that this is right. But I was going to make a point.
He used the word compelled the decision.
It compelled the decision. I mean, just as he says Curtis is wrong, we say Molloy is wrong. It's not for you. As I say, one of your judicial colleagues will in due course have the pleasure of deciding who's right and who's wrong about it. Then, and I picked up several of the points. The second point, Sudlows chose to define the window number 5. Now that is code for saying, well, you should have asked for a declaration of the ongoing effect. 2 points about that. One is, in the actual, 3 points, sorry. In the actual reasons itself, Mr. Curtis refers on several occasions to the ongoing and continuing effect. Secondly, if you look at the substance of the dispute was whether or not there was an ongoing effect. Thirdly, if it really does matter whether we said we'd like a declaration that this had an ongoing effect as opposed to an extension of time up until the 18th of January, you are going to make lots of decent work for lawyers, but the actual practical effect for the construction industry will not be satisfactory. Then the next point is the claims are ongoing and in relation to a new period. In my submission, this really is an unrealistic point. The impasse had been reached, it had been going on, it was resolved, and one sees how, and no doubt if it had been resolved the other way, we'd have had to take some steps to do something about it, we'd have complained about it, and so forth. But it was resolved. The nature of the analysis does not change one jot between the period before the 18th of January and the period after the 18th of January. It is either the same dispute or it is substantially the same dispute. Then the account of the new material. The new material point only comes in if there's jurisdiction to consider it.
Yeah.
If the adjudicator had said, look, that's all jolly interesting, but these are precisely the same arguments, and you've got some additional points you want to make, and I'm not considering any of this, it goes nowhere. And
It can't. The fact that there's new material can't actually shed any light on what the scope of the dispute was.
My lady, precisely. I shall move on. The new evidence of the future events in time, well, I've really already made this point. The future events in time is actually only some analysis of what happened after the end of the contractual period. It's nothing more than that. The respondent point, in my submission, this is a thoroughly bad point. If they'd done what they should have done, they would have accepted the existence of a further extension of time. And it ties in with another point, which is that Malone Friend's clients argue, but the logic of their case comes to this. We only sought an extension of time. Although the definition of relevant matters and relevant events is exactly the same, well, and although you've got an extension of time, you can't have any loss and expense because we're entitled to refight the battle in relation to that. Now, that's the case he was putting in relation to what Mrs. Justice O'Farrell, he says, found in Global Switch. And his clients were putting that, but that is actually where the logic of his position goes. There's no logic at all for him to stop at the 18th of January. Mr. Molloy did that, and he can't do any better, but the logic has to be, if this is a different dispute, and if you don't ask for loss and expense, then even though it may well be very sensible to get the loss and expense sorted out before you do, to get the extension of time sorted out before you get the loss and expense, you can then rerun the whole matter before another adjudicator. Well,
So when you say it was Molloy who stopped,
Mr. Molloy's alternative case.
yeah, stopped at the 18th of January, you mean working back?
Yeah.
He did loss and expense, alternatively working back from the 18th of January, but not before.
Exactly. And
But you say the logic of the argument is that actually he could have, if Mr. Nissen was right on the other points, he could or should have gone back to the beginning.
absolutely.
Yeah.
And
Yeah,
that is, as I understand it, what my learned friend was submitting the effect of Mrs. Justice O'Farrell's decision was. If that is what she was saying, and I do respectfully, I mean, the point...
Well, you made your point about them.
Yeah, I mean, it is, just to make the one obvious point, when a judge does something which is obiter, it's not always the case that they concentrate as closely on the alternative grounds as they do on...
In my experience, Mrs. Justice O'Farrell doesn't waste a word. And
I
I'm not prepared to accept that.
At 4:30, I shall move on. I think I've done it. That was a whistle stop. But if there is any point which you'd actually like some further assistance on, I shall try and give it to you. But those are the points.
Let me just, because it was very helpful to do it by way of the 11, and I'm just looking to see whether...
I hope to have covered the ones which I've skipped over, which I've dealt with in some of the matters before.
Yeah.
I didn't deal with floodgates, but I mean, you've got points in relation.
Well, you've both got floodgates arguments, not uncommonly. And not uncommonly, at the moment, my bet would be it's unlikely that this case will be decided either way by a floodgates argument.
I didn't address
I don't obviously want to bind my ladies, just speaking for myself.
Well, floodgates in the current situation on the Dnieper River, and that'd be rather
Yeah, okay. Right.
I, for my part, apologise that
No,
that
that was fine. I was warned that this was more than half a day, so we did make suitable provision. All right. Thank you both very much. Thank you to the teams sitting behind you. was observing to my judicial assistant, Will, that when I sit with other colleagues who do some construction work, but not perhaps as much as I do, I always like it when at lunchtime they say, "This is really interesting." So that's a tribute to you both and the people sitting behind you. You won't be surprised to learn that we will reserve our judgments, and we will not be in a position to say at the moment when those will be, but you can rest assured that we will do them as quickly as we possibly can. When you get the draft judgments in the usual way, those are drafts so that you can check our typos and any minor factual errors that we might have made. It is not, obviously, an opportunity to re-argue the case in any way. The drafts will be sent out under the usual now standard warning about the dissemination of drafts to anyone other than the people on the list. My clerk has helpfully been provided with the names, the email addresses effectively of the 7 email addresses to which it will be sent. So it will be sent only to those 7, and therefore it will be those 7 to whom the embargo rule applies. Unless there's anything else, that concludes the hearing. Thank you both very much.
All right.